Hello, you're watching Health Day Now. I'm Mabel, Jong. Few are ever truly ready to see the physical and mental decline of their parents as they get old. And it could be more painful and complicated if a parent is put into guardianship or conservatorship, which is legal. But as Britney Spears' case demonstrated, the arrangement can be easily abused. Even the most diligent people can find themselves abruptly cut off from their parents. With me now is Dr. Sam Sugar, an internist and founder of Americans Against Abusive, Probate, and Guardianship, and Jasmine Harris, law professor at the University of Pennsylvania with a particular focus on disability law. Welcome to you both.
Thank you.
Thank you for having us on the program.
Dr. Sugar, let's start with you. You started your advocacy group over 10 years ago in response to the circumstances surrounding your mother-in-law, who was suddenly in the care of a court-appointed guardian when family members couldn't agree on her care?
That's exactly right. A professional guardian was appointed by the court because the judge, in this case, an administrative officer of the probate court with no juries, no rules of evidence, no rules of procedure, just one person's opinion, decided that no one in the family should actually be able to take care of this beloved maternal figure, and instead appointed a company, a for-profit company, that billed a minimum of $85 per hour for anything remotely having to do with her existence or care. And they could get away with it because as guardians, they owned that human being. And as long as there was a signature of a judge over what they planned to do, no one else's opinion mattered.
Professor Harris, how is the conservator system supposed to work?
You mentioned conservatorship and guardianship, and these are two names for what are fundamentally the same institution. The roots of it, actually, quite interestingly, especially thinking about cases like Britney Spears, it's rooted in the king's interest in property. And whether that's real property or financial assets, that was the root of the guardianship system. And so the state has this interest in protecting the interest of people deemed to lack legal capacity. That could be children, that could be older adults, and most often people with disabilities.
It's supposed to be the first choice for the judge to make the last choice of a guardianship and give it to a family member. Often that does not happen, in particular when there are large amounts of money in question. And these are the cases we see repeatedly. And of course, Britney Spears is just one example. There are many, many, many others in which this last resort is come to as a first resort when families cannot agree on what the best thing to do for their loved one is. Even if there are advanced directives like healthcare powers of attorney and durable powers of attorney, the judge will say, a pox on your house, a pox on your house. I'm appointing somebody I trust, somebody I've worked with many times, to be the owner of this person, and I believe that they will do the best job. Now, unfortunately, any system that depends on the goodwill of a person who's being paid is a system that is bound to fail.
Professor Harris, can I have you weigh in here on what Dr. Sugar is saying?
There are two main ways in which guardianship will start, and the petition will be filed by a hospital, a government agency, when they think that the individual perhaps lacks the capacity to make decisions about health or other types of decisions. Usually they're not propertied individuals. Or the second most common, though not talked about, route to guardianship is the pipeline that goes from schools to courts. And what happens is when someone who is a special education student reaches the age of majority, when they turn 18, many school districts around the country will say to the adult, the rights holder, the parent or the guardian not in the guardian formal sense, but the person who is caring for the child, look, your child is reaching the age of majority. If you want to stay involved in their health, if you want to stay involved in their education, you need to go to court. You need to go and ask for a guardianship. And so those two routes are most often people who don't have the resources. So they're not the Britney Spears of the world, and they're disproportionately people of color.
Now, with the singer Britney Spears, it was allegedly dementia-related issues that she was dealing with that landed her in a conservative arrangement with her father. What other conditions and types of people would fall under a potential need for a conservatorship?
In terms of conditions, we see, if you look at the cases that are available, and one issue is the lack of accountability and transparency, most of those cases are dealing with people across the board. They don't all have, particular diagnoses. Sometimes it's just the precipitating event is that they're making decisions that are not deemed in others' eyes to be appropriate. And so we do see people who have intellectual and developmental disabilities. We talk about particular conditions. I think dementia is related to older adults. So we see a lot of people who are older adults who are coming into the system that way as well.
Dr. Sugar, the number of guardianship cases in Florida is soaring, more than 3,500 active cases in Orange County alone. The number of professional guardians will likely grow too. Was the guardian appointed to your mother-in-law licensed or trained?
The guardian in this particular case was not licensed because there are no licenses for guardians in the state of Florida or many other states. What's required is a certification, which one can obtain by taking a weekend course and a little continuing education and being 18 years old and a high school graduate. That qualifies you to take care of a multi-million-dollar estate with no additional financial planning, education, or experience. Basically, almost anyone can become a guardian, and the system of monitoring and supervision of guardians across the country, including Florida, is highly, highly suspect. It just doesn't work very well because it depends on reports from the public to activate what little monitoring and supervision is available.
Dr. Sugar, more specifically, how did you first become aware of potential abuse in your mother-in-law's case? What were the red flags there?
The red flags included, but weren't limited to, isolation, being told that the ward would not be able to receive visitors without express permission of the guardian, would not be able to leave her apartment to play bingo, for example, without the express permission, was not able to go out to have ice cream or lunch or dinner. And of course, what followed was the financial exploitation, specifically guardian fees at a ridiculous rate and a ridiculous number of hours, and the endless legal fees that have consumed millions and millions of dollars in this case, and have notoriously consumed entire huge estates with endless years of litigation. Those are the cases that get referred to us and that we attempt to counsel people on.
The problem with guardianship is that it's based on two faulty premises. The first is that it's a system that operates in the best interests of someone. And because of that, what flows by design is that it's closed proceedings. You have what Sam is mentioning in terms of things filed under seal. As a researcher, as a legal scholar, it makes it very difficult for me to get the actual pleadings in cases and the information I need to provide the accountability that the system needs. The second factor is it's based on a faulty premise about decision-making, that somehow the decisions of certain people are inherently suspect. And that was the special classes of people that I mentioned: children, older adults, people with disabilities. And so in many ways, they are not given what's called the dignity of risk. And the dignity of risk is, in my eyes, one of the most beautiful poetic ways to describe what we're all given, which is the right to make bad choices and good choices and to learn from them, right? So there's an iterative part of it. And then with respect to the systems themselves, guardianship proceedings do have rules. They do have rules. They have rules of evidence. They have rules of procedure. The problem with it is that it is in a black box. And it's also controlled by a judge. And this system, like I said at the onset of our conversation, this is a system that was designed completely distinct from our common law system that's adversarial, where judges drive the action in the case. I'm sorry, where lawyers drive the action in the case. There's a defendant and a plaintiff. In these types of proceedings, it is jumbled. It's everyone presumed to be acting in the best interest. So I think it's important to just be clear that there are rules that guide and govern these proceedings. The problem is the lack of transparency, the informality, and the cultural norms that are guiding these interpretations.
And the financial incentives that drive those actions as well. The profit motive for people involved is what we call court insiders, is very substantial. There are estimates that the amounts of money controlled today in American guardianships is over $50 billion. And that's low-hanging fruit for people who make their living doing this with very little or no supervision or monitoring.
If the situation is shrouded in secrecy, what should a family do if a conservator was appointed and they spot danger? Who should they contact? Where do they go?
I would say the very first thing to do is to prevent a guardianship. No one really wants a guardianship. And the way to do that, at least in our situation where we see primarily older people involved in guardianships, is to fix your family problems, solve your discrepancies and your disputes so you never have to walk through the door of a probate court. The other thing that we recommend strongly is to have your advance directives perfectly drawn up to include a statement that you do not wish to have a guardianship unless absolutely no other options are available.
Professor Harris, is it ever a good idea to bring in a conservator when a family just can't agree on how to manage their parents' affairs?
No, Mabel, I think that the answer is really, how do we rethink this system? I do think that we need to really take that step back and say, what supports are already in place? Can we do this in a less restrictive way, which is the law? And by the way, many state laws right now on the books say that this is the nuclear option. And so it's not necessarily a problem of law reform itself. It's a problem of cultural reform, how we understand decision-making, how we understand disability, and how we understand the fundamental rights that are at issue here.
Dr. Sam Sugar, an internist and founder of the advocacy group, Americans Against Abusive Probate Guardianship, and also Jasmine Harris, law professor at the University of Pennsylvania. Thank you to you both.
Thank you.
You've been watching Health Day Now. I'm Mabel Jong.